Swayam Prabha. Digital India. Educated India.
Welcome students to the class of Transfer of Property Act. This is lecture number 19 and it deals with transfer of actionable claim. Prior to this I have discussed gift essentials in previous lecture. Myself Dr. Amrendra Kumar Ajit from Faculty of Law, University of Delhi. So, first of all, we will have to see that what I am going to cover in this module, this lecture. So, first of all, I will cover the definition part of actionable claim, then section 130, then kinds of debt, then a case Sunrise Associate versus Government of NCT, types of actionable claim, types of non-actionable claim, and then after section 131, 132, 134. Okay. So, let us start with definition clause. Definition of actionable claim. What is actionable claim? It is defined under section 3. So, according to the definition of section 3, actionable claim means a claim to any debt other than debt secured. That means the debt which is secured, that means a mortgage will not fall under this category. So, any debt then by a mortgage of immovable property. Actionable claim is a kind of debt other than debt secured by mortgage of immovable property or by hypothecation or pledge of movable property. Because in case of mortgage, subject matter is always immovable property. In case of hypothecation or pledge, subject is always movable property, and both governed through the different laws. Mortgage governed through the Transfer of Property Act, and I have already discussed in the previous lecture, and pledge is governed through Sales of Goods Act. So, if any kind of debt which is secured, that will not fall under the category of actionable claim. Rest of the type of debt will be covered in this. So, next point is any beneficial interest in movable property. That means, in addition to unsecured debt, any interest, that is beneficial interest in movable property, but that movable property should not be in possession of the claimant. That means, there are certain interest, beneficial interest in movable property, that movable property should be within the possession of others, not within the possession of claimant. So, which claim the civil court recognize as affording grounds for relief, whether such debt or beneficial interest be existence, occurring, conditional or contingent. Okay. So, these are the types of interest. It may be existent, it may be accruing, it may be conditional, it may be contingent interest, but in all kinds of these interest, there may be actionable claim. Okay. So, first is unsecured debt, second it is about any beneficial interest. Then according to the amendment in 1900 in this act, the actionable claim under this section comprise of unsecured debt or a claim of any beneficial interest in movable property not in actual or constructive possession of the claimant. So, that means, it should not be in the possession of claimant, whether it is in the constructive form or in actual form. Then these two above mentioned claims, that is unsecured debt and beneficial interest over immovable property, beneficial interest over movable property, these two mentioned claims are aptly recognized by the courts. Okay. So, here you can see the heading is actionable claim not covered under the Transfer of Property Act. That means there may be the other kinds of actionable claim in addition to these two, okay. But those two are not going to be covered under Transfer of Property Act, because any kind of interest, any kind of claim over certain kinds of things will fall under the actionable claim. Okay, just you will see the example that a claim for a secured debt, a claim in case of tortious suit of nuisance or defamation, these are also a kind of claim over the rights of other. Okay. So, these are also a kind of claim and these are actionable, because a person who want a compensation for the case of nuisance or compensation in case of defamation, that is also a kind of claim, okay. And that is a valid claim, but these are not covered under Transfer of Property Act. So, however, these are not covered under the definition of actionable claim under the TPA Act. So, previously all kinds of claim in movable property which could be enforced through the courts were included in the term of actionable claim. Earlier, that was the concept, that all kinds of claim, but now it comprises only to unsecured debt and claim to any beneficial interest over movable property. So, all actionable claims are not covered. So, whenever we are going to discuss about the actionable claim under Transfer of Property Act, then it is about unsecured debt as well as beneficial interest over movable property. Now, this debt, that is how it generally originate. So, first of all, there must be a clear concept about the tangible and intangible movable property. It is not about the immovable property. Tangible, movable and intangible movable property. So, tangible movable property, it is very clear that we can see it, that means just like a pen, car and books, camera, all these things are kind of movable property. So, these are visible, but what are those invisible, intangible movable property? So, these intangible movable property, they remain in the form of rights, and these rights are a kind of claim. So, intangible movable are in the form of right which have no physical existence and cannot be possessed, but a person will be entitled to claim that kind of claim from due to existence of that right. And this right itself, that is the claim, is a kind of right. Why there is a claim? Because there cannot be a claim unless until that claim has been recognized under the right. So, for that purpose, to some extent the concept of tort here is necessary, that where tort and jurisprudence both, that where there will be claim, and claim over what? If your right has been infringed. So, if the right has been infringed, then only you have a claim over certain things. So, this claim may fall in the category of actionable claim, and the debt is also a kind of actionable claim, because it is also a kind of claim first of all. Okay. First of all, it is a claim. Claim here means legal claim. Legal claim means the claim which is recognized by law. So, certainly if it is recognized by law, why? Because your rights are recognized by law, because if the rights are not recognized, then claims will be not recognized. Okay. So, here debt is also a kind of claim, that means whoever has taken this debt, that is creating a obligation to pay it to the person from he has taken that. Okay. So, a sum of money due by a person, one person to another, which includes not only amount payable at a time, but also sum of money which is not immediately due, but might become payable after some time. That means date may be the on existence, just we have discussed earlier, that claim may be existence or it may be the future claim, but that right must accrue at that time. Okay. So, sum of money which is payable or will become payable in future by reason of a present obligation is date under Transfer of Property Act. Okay. So, payable in future by reason of present obligation. Okay. That means there is a relationship that this future claim or this date is due to the existence of present obligation. That means there must be existence of obligation at the that time in the that time means at the present time, and there may be the date in the future. So, it is a sum of money which payable or will become payable in future, that will be also a kind of date here. Then secured and unsecured debt. So, it is very easy that when we are going to give, when you are going to give a security against the debt, then it is secured. If there is no security, then it is unsecured. So, debt may be secured or unsecured debt, where the debtor gives security for payment of debt to the creditor is known as secured debt, and where no security is given, it is unsecured debt. And claim here is about, because here actionable claim is about this unsecured debt. Okay. Here in case of actionable claim, the date is actionable claim cover only this unsecured debt. It is not covered the this one which is the secured debt. Okay. Debt to the secure debt, it is not covered under the actionable claim. So, only unsecured debt is being covered. So, not every kind of debt qualifies to become actionable claim. In case of Sunrise Associate versus Government of NCT of Delhi, Honorable Supreme Court observed that actionable claim could be claimed in debt, existence in presenti, accruing, conditional and contingent. Okay. So, debt may be of 4 type according to the timeline or according to the happening of event. According to the timeline, what will happen? It is presenti or accruing. Accruing, that means here, accruing here means, that means the things are going to be paid in future, but right has been always created, as well as there is a creation of date also on from that date itself. Conditional and contingent is about on the happening and non happening of certain event. So, in this case, it has been said that therefore, only the following 3 types of unsecured debt are referred to as actionable claim to an unsecured debt. Okay. 3 types of debt here is, one is existence, that is at the present time. It refers to a debt that has become due, payable and enforceable presently. That means, now the debt has been created, amount is due, it should be payable and it may be enforceable. Okay. That means, everything is clear, everything is clear means the debt has been already created, it is now it is payable, right has been created to be paid, as well as it can be enforced also. So, in that case it is debt in existence, this is actionable claim. So, here example it has been given that if Mr. S, the seller, sells his land to Mr. B, the buyer, for monetary consideration of 10 lakh. It was agreed between the parties to the sale that the price of the sale transaction has to be paid then and there. Okay. That means, under this sale, price must be paid at the time of transaction itself at the same time of the execution. Hence, in such case, where the sum of the money becomes payable, right then it is an existing debt. Okay. That means, the amount which has been gone into the form of debt at that time itself, that means then and there it is being created, right has been created. Now, persons are entitled to claim that. Okay. Persons are entitled to claim that, and they are entitled to enforce it, because suppose I have purchased some land, and then after I have paid only half amount, or I have not paid at all, but now the possession come in my hand, okay, deed came in my hand, then in that case what will happen, that my duty will arise, that okay, now this is the kind of debt which I will have to pay to the transferor, that amount. Okay. It may be 10 lakh, 20 lakh, whatever it may be, but if the things are already came to me, but I have not given that consideration. Okay. So, that consideration which has been not paid, now it has been gone into debt, and this is in existence, it can be enforced by law. So, transferor will have right, because these things we have already seen in the case of sale, okay, under section 54. So, transferor will have right that those things which are, that means the debt or consideration, due consideration, he can enforce against me. So, this is the existing debt. Then accruing debt. In case of accruing debt, what it says, that the monetary obligation has already become due in this kind of debt, but it is payable only on a future date. Okay. Only on the future date. That means, this obligation has been already created. Okay. Obligation has been created, but right to claim has been not created. Right to claim will come in future, and when in future also he will be able to enforce, not at the present time. So, it is saying that it is accruing it. Example, here it has been given, that if Mr. E is an employee working for Mr. A employer for a salary of 50,000 per month. The contract of employment provides that Mr. E shall receive his salary for the month on the last day of that month. In this case, the salary is due throughout the period, but it becomes payable only when the last day of month comes. Okay. Therefore, it is a kind of accruing debt, because if you will go through that monthly day basis, so per day his right is generating, that means whatever he is working for per day, his or her remuneration, here Mr. E remuneration is generating. Okay. But he cannot claim every day, he will claim salary at the end of the month, okay, the last day of the month or the first day of the next month. So, in that case, here it is accruing per day, but claiming right is going to come in future, that is means the last day of the month or first day of the next month. In that case, it is accruing debt. Okay. Then next is conditional or contingent debt. That conditional and contingent you might have read in the contract itself. So, a debt is termed as a contingent or conditional debt when it becomes payable only on fulfillment of condition of contingency contemplated by the transaction. Okay. That means, certain conditions has been mentioned when it becomes payable only on the fulfillment of condition, okay, or contingency completed by the transaction. Then only it then this debt will be called as conditional or contingent debt. Example has been given that P agreed to pay Q 10,000 rupees. P agrees to pay Q 10,000 rupees if Q buy the house of R. This is the condition. Okay. P agrees to pay Q 10,000 rupees if Q buys the house of R. So, unless and until Q is not going to purchase or buy the house of or till then P will not pay this amount. Okay. So, this is a conditional debt as fulfilling the condition as stipulated therein depends upon the Q's conduct. Okay. So, he can claim 10,000 rupees from P only upon the satisfaction of this condition on his part. So, unless and until that condition is not going to be met, then this P is not entitled to claim that thing. Okay. In same way, so it has been said that more specifically, when the stipulation enumerated is within the control of the party to the agreement, it is known as conditional debt. Okay. Conditional debt. That means the happening or non-happening of the event is dependent on the conduct of the parties. Okay. Then it is conditional. But when it has been said that the control or this condition which is going to be put in the contract of this, if it is not within the control of parties, or we can say that if it is not within the control of human conduct, okay, then only it will be contingent. That means, it is beyond the control of human being. So, it will be beyond the control of the parties also. Okay. So, those type of the condition which is not dependent on the conduct of the parties, which is beyond the control of the parties, then only it is it will go under the contingent things. Okay. So, here P promises to pay 10,000 to Q, the similar example, but if it rains on a particular day, now it is not that he is going to purchase someone house. Okay. Here it is rains on a particular day. So, raining on a particular day is not within the capacity of any individual. Okay. Or raining on a particular day is completely the out of the control of the human conduct. So, it is a contingent event. Okay. So, since the one more thing that in case of contingent event or date, it is not necessary that always it is non-human conduct. Sometimes take the example of that if something A promises to pay 10,000 if government is going to issue this policy. Okay. So, government is going to issue this policy, that is it is by the government, by the member of the government. Okay. So, if they are going to do this or they are not going to do this, then only P is going to promise, even then that will be the part of the contingent, because it is beyond the control of the parties. Party will not have power to control that situation. So, that will also fall under the contingent. So, rain here is completely a act of God. Okay. And it is beyond the control of human conduct. So, in that case this will be the contingent condition. So, since the contemplated stipulation is beyond the control, the debt incurred is a contingent debt and it becomes payable from P to Q only when it rains on a specific day, rains on the specific day. Okay. Now, one this example is not only from the act of God, but even certain examples may come on from the society itself, that something is happening, something is not happening, that may fall under this, but it must be beyond the control of parties. Then there are certain claims which were decided by the courts as an actionable claim. Okay. So, one by one I am going to discuss the list of the claims which are accepted as an actionable claim and list of the claims which are not accepted as actionable claim. Because why this is important, unless and until the meaning of actionable claim is not clear, then till then you will not be very clear about the transfer of actionable claim. Okay. Because the topic is transfer of actionable claim. So, for understanding the transfer of actionable claim, first of all actionable claim must be understood properly. So, it says that claims of arrears of rent. Okay, claims for arrears of rent. Okay, so this is an actionable claim. And what type of claim it is? If you will go through these three, you can identify that claim of arrears of rent. Arrear is, that means rent is going to be increased day by day, per day part of the rent will be added, but any renter or any owner will give that rate or will ask that rent only at the end of the month. Okay, so it is a kind of accruing debt. Then share in partnership. A share in partnership is what? It is also granted as actionable claim. Okay, and actionable claim, that means it is a present claim, existent claim, because the partner is in existence. So his share, his percentage share in the partnership is an existence condition, and that will be a kind of debt claim. Then claim for the money due under any insurance policy. Claim for the money due under any insurance policy, that is also actionable claim. All these claims you can correlate with the rights, okay, because these claims are a kind of rights which is going to be in the form of claim. Okay. So this is the right of the policy holder to claim insurance money in certain cases. Okay. Then the claim for rent to fall due is future accruing debt. Claim for return of the earnest money. Claim for the return of earnest money, it is existent debt. Okay. Then claim for unpaid dower of Muslim women. Unpaid dower, okay, dower is a right of Muslim women, and if had it remained unpaid, then it is existing debt and it will be a kind of actionable claim. In same way, right to get back the purchase money when the sale is set aside. When the sale has been repudiated, revoked due to certain conditions, okay, in that case the seller will have right to take back his money. Okay. Seller will purchaser will return that seller will return that money to the purchaser. Then the benefit of the executory contract for the purpose of goods is a beneficial interest of the movable property. Okay. Then right to proceeds of a business, that is also a kind of actionable claim. Now come to those claims which are not accepted as actionable claim by the courts. Okay. First is a decree is not an actionable claim. Okay. Suppose there is a decree and within that decree some amount has been given. Okay. So once the decree has been given, then there will be this will not fall under the category of actionable claim. Why? Because the claim which is already settled, okay, claim which is already decided. So now it is not actionable. It was a claim till the proceeding was going on. Okay. So that kind of the claim may fall under the category of actionable claim. But once the decree has been pronounced, so the claim has been settled, now only the execution is remaining. So there is no claim but only execution. So rights to get damages under the law of torts or for breach of contract. Okay. So right to get damages under the law of tort or for breach of contract, they are also non-actionable claim. A claim to make a profit is not an actionable claim, but it is a mere right to sue. A copyright is not an actionable claim. Debt secured by mortgage of immovable property or hypothecation of the movable property, because it is a part of the definition itself. So here it should not be any doubt with regard to this. Okay. So in all these cases, the court had said that it is not a kind of actionable claim. Then now transfer of actionable claim. Okay. Transfer of actionable claim. That means when this kind of the claim is going to be transferred, then how it will be transferred? how these rights and liabilities of the transferor and transferee will arise, how it will be settled. So, that we are going to see in this. So, come to section 131st, okay, where the transfer of actionable claim has been defined. Okay. So, it says that according to section 130 of Transfer of Property Act, okay, and the subject matter of this module is this transfer of actionable claim, but without reading the definition of actionable claim, this would not have been cleared. So, it is the mandatory requirement within the module itself that first of all there must be a kind of clearance of doubt with respect to the definition of actionable claim. Then only whatever it is going to come under this module or chapter will be able to understand properly. So, this section 130 says that actionable claim can be transferred. Now, you can remember all those claims which has been accepted or may fall under the category of those claims may be transferred, because they are still pending. That claim is not settled, but those claim may be transferred with or without consideration. First of all, with or without consideration, that actionable claim may be transferred with consideration also and without consideration also, by way of an instrument in writing. This is very important. By way in instrument in writing duly signed by the transferor or his agent duly authorized in this respect. So, first of all, there may be the transfer of actionable claim with or without consideration, and with instrument. Without instrument, any actionable claim cannot be transferred. That means, there will be no transfer of actionable claim orally. Okay. Any kind of actionable claim is going to be transferred, it must be in a written form. So, thus oral transfer of actionable claim is not permitted at all. Okay. However, its registration is not necessary and no separate instrument of transfer is to be affected. Okay. So, a registration is not required. So, there should not be confusion at this stage that if there is no registration is required, meaning thereby there is no requirement of instrument. No, instrument is something different and registration is different. Instrument is between parties. Okay. The written agreement between parties is instrument, and when that instrument is going to be registered, then the state agency will come. Okay. So, if you are going to register it, then you may register, but it is not a requirement. It is not a requirement. So, it has been said that it can be done only through the written agreement itself. Okay. Registration is not a requirement at all. So, no separate instrument of transfer is to be affected. Okay. So, there is no requirement of any other instrument that there is a transfer. Okay. So, only the what is the contract between the transferor and transferee, that this actionable claim is being transferred from this person to that person, that is sufficient. Okay. Whether it is with consideration or without consideration, it must be mentioned in the deed itself. Then the principle of this section is that assignee can get no better title than the assigner, because this is the basic fundamental principle of all kinds of transfer, not of this one. Okay. Not of this one, not only of actionable. If we will start from the sale itself, whether it is sale, whether it is mortgage, okay, whether it is in the case of lease, whether it is case on actionable claim, whether it is in case of gift. In all cases, if you will see, then any transferor of these kind of transfer cannot transfer better title than what he has. He can transfer lesser title, just like in the case of lease and mortgage, but he cannot transfer better title at all. Okay. But in case of sale, in case of gift, in case of transfer of actionable claim, okay, so he cannot go even below that, that whatever it is transferring, okay, whether it is in the form of sale, gift, or here even in case of this actionable claim. So, whatever he is transferring, he cannot transfer better than this. So, it is immaterial that the assignee had no notice of equity or liability to which assigner was subject to the date of the assignment. The principle of this section has been applied to the court sales. Okay. It is immaterial that assignee, that is transferee, had no notice of the equity of liability to which the assigner was subject at that date. Okay. So, to whom it has been assigned, that means actionable claim is there, actionable claim is there. So, here it will be assigner and it is assignee. Okay. It is assignee, A2 is assignee and A1 is assigner. So, it is saying that immaterial that assignee had no notice. This person has no notice, no knowledge about that what he is transferring, A1 assigner is transferring, okay, on the date of assignment, what is there was certain kinds of liability. What? No notice of the equity or liability to which assigner was subject at that date. Okay. So, it is actionable claim in itself, actionable claim in itself. So, it is itself is a kind of liability first of all. Okay. So, whoever is going to take actionable claim, whoever is going to take that actionable claim, being a assignee or transferee, okay, in that case he is knowing that this liability he is purchasing, okay, he is purchasing and this is going to come on his part. So, in that case it has been said that it is immaterial on the part of assignee whether it had that notice or not, because this is not about the mere form of sale or something like that. Actionable claim is like that, this is a kind of a claim against certain thing, certain person, certain date, certain kind of thing. Okay. Whether on that actionable claim is there any other kinds of liability or not, that is not, even though it is not known to the assignee, it will not hamper the transaction or transfer. Assignment of non-performing assets between banks and financial institutions is covered by RBI guidelines. Okay. The provision of Transfer of Property Act does not apply in these cases. Okay. So, in case of non-performing assets, for non-performing asset, if there is a transaction between banks and financial institutions, that will be not governed through the 130 section of TPA. Then mode of assignment. Okay. What is the mode of assignment? Mode of assignment of an actionable claim is given under 130 section itself. Okay. And what is that? It must be in a written form. It must be effected by instrument in writing, okay, signed by the transferor or duly authorized agent. That duly authorized agent, it is not necessary that assignments should be made by a separate document. Okay. Assignment is not necessary that it should be made by the different document, that means in which the things has been transferred, that document, one single document is sufficient. Only an endorsement on the back of a document containing the actionable claim is sufficient for the purpose. Okay. Just that endorsement that he is transferring this kind of the claim and he is the owner of that claim, it is going to be transfer, that is sufficient. There is no requirement of any additional document for assignment. Okay. So, within a single document it can be done. The most important is effect of assignment. What will happen, okay, after assignment, because all these things, all this transfer creates, and first of all any transfer changes the rights and liability as well as creates the rights and liabilities on other side. Okay. So, transfer of actionable claim takes effect only after execution and signing of instrument. So, first of all this transaction must be completed. Transaction must be completed means the actionable claim has been transferred. Okay. Claim has been transferred. Now, the person who is taking, that means assignee, will have all kinds of rights and duties like the assigner. Okay. Because what happens in the case of actionable claim, that suppose A is the assigner and property or something, a claim is here X, and A has a right over that, because it is a kind of claim over X. Okay. So, X is a actionable claim, then he is transferring this to B. That means, this claim is going to be transferred to the B. So, now B will go in place of A. B will go in place of A, and B will have all rights and duties. B will have all rights and duties like A had. Okay, like A had. So, it says that a assignee or transferee becomes entitled to recover the claim and sue on his own name. That means, earlier A was entitled for any kind of the claim over X through his own name, but now B will be entitled because B is the owner of that actionable claim. Okay. So, B will get all the right of A, because it will not happen. If it will not happen, then what will happen? B, this transaction will remain futile and it will not serve the purpose. So, all the rights and liabilities, it is generally go to the transferee or assignee. So, the assignee also become liable for all liabilities and equities to which the transferor was subject at the time of transfer. That means, he is B will not have only the right, B will have also liabilities in equity or any other kinds of liabilities at that time, which at that time of the transfer. Okay. So, at the time of transfer, whatever the duties or liabilities was on A, that will by default it will shift to the B. Okay. And whether the B had knowledge about that liabilities or not, it is immaterial, because previously we have seen that in that case this assigner the subject, this nothing, assigner gets nothing. Okay. So, it is immaterial that assignee had no notice or equity of liability to which the assigner was subject at the date of assignment. Okay. So, that kind of the liability was on A, whether it was within the knowledge of B or not, it is completely immaterial. B is bound to take that responsibility, those liabilities, if transaction has been completed. Okay, in this. Then there is a notice of assignment. Okay. A notice of assignment to the debtor is not compulsory to perfect the title of assignee, but until the debtor receives notice of assignment to a third person, his dealing with original creditor shall be protected. Therefore, the assignee must give notice to the debtor in his own interest as early as possible. Okay. So, notice of assignment. What is the notice of assignment? Again you will have to understand this. This is a person who is a assigner. Then suppose this is the claim X, and this claim is with respect to Mr. Z. Okay, this claim is with respect to Mr. Z, and B is the assignee. B is the assignee, that means A is transferring this X claim to B. Okay. So, B will be responsible to pay this claim to Z, because earlier A was responsible towards Z for X claim. Now, B will be responsible towards Z for X claim. So, what it is saying, that notice of assignment, that means this A is going to assign this claim X to B now. Okay. This knowledge to Mr. Z, okay, to Mr. Z, that A is transferring his claim to Mr. B. Okay, the notice of assignment to debtor is not compulsory to perfect the title of assignee. So, this notice is not a compulsory requirement first of all. Okay. Debtor it is not a necessary requirement, but until the debtor receive notice, okay, until the debtor receive notice, because A is here creditor, okay, and Z is here debtor. So, Z is here debtor, that means creditor will have claim against Z, return that money. Okay. Creditor will transfer his claim to Mr. B. So, what he is saying that the debtor is not, this assignment to the debtor, notice of assignment to the debtor is not compulsory. That means, A is not bound to give this knowledge or notice to debtor Z that okay, I am going to transfer my claim to Mr. B. It is not necessary, but until the debtor receive notice of assignment to third person, that means A is, unless Z is not going to receive that notice that this claim of creditor has been transferred to third person, his dealing with original creditor shall be protected. So, whatever, that means he will return that money to A, because he is not knowing that who is the third person to whom this claim has been transferred. So, what he will continue, because he is knowing that A is the creditor, it may be possible that claim might have been transferred and A has not discussed all these things to Z, and after transfer Z is continuing to take that claim, okay, or that money, principal money, then here A is committing fraud. Okay. But for this fraud, Z will be not responsible, okay, because Z had no notice towards it. So, what it says that therefore, the assignee here means Mr. B must give notice to the debtor in his own interest as early as possible. So, it is the duty of B that give notice of this assignment, this transfer to Z, that see Mr. Z, now I am your creditor. Your creditor has been already transferred the actionable claim. I have already paid that amount. Now, whatever there is a due, that is now due towards me, not towards A. So, whatever you are going to pay, you will have to pay me, not to A. In that way, B interest will be protected. Otherwise, what will happen? A will remain in continuation to pay that amount to B. Z will remain in continuation to pay that amount to Mr. A, and it will be harmful for the B. So, for B's own interest, B will do that. Otherwise, this is not a legal duty. This is not a legal duty. But if there is that kind of confusion, miscommunication, not communication at all, it will create a problem for the assignee. So, assignee, to protect his own interest, it is better that he will give that notice of assignment to debtor. Clear? Now, come to the notice to be in writing and signed, section 131. The notice is not necessary, as we have seen, to ensure perfection of the transferee title of actionable claim. However, the dealing of the debtor with the creditor are protected until the former receive the notice of such assignment in observance of the condition enumerated under section 131. So, if there is notice, then what is the format of notice? What are the requirement of notice? So, according to section 131, what it says that a notice of transfer of actionable claim has to be in writing. Okay, has to be in writing. It must be signed by transferor or his authorized agent on his behalf. It must be signed on the behalf of transferor by the transferor or on the behalf of transferor by his agent. And however, if the transferor refuses to sign it, then in that case it must be signed by the transferee of actionable claim or his duly authorized agent. Okay. That is also a you can say saving clause, that sometime it may happen that now this creditor is not signing. Then what will happen? And transaction has been completed, okay, because this notice is not mandatory. Creditor may say that, okay, notice is not mandatory, why I will sign? So, in that case what will happen? Notice is going to be given, then the assignee will sign that this transaction has been completed and this is the notice to you, and assignee will sign it. Okay. So, that is the format of notice. The notice must be an express notice in writing and it must state name and address of the transferee. The notice which did not give the address of the transferee was held to be invalid. Okay. In which the transferee address has not been mentioned, that has been said that it was a invalid notice. Okay. In case of Hansraj versus Natho, this is a very old case of Bombay High Court. Then second is a notice which does not mention the date of assignment or contains and or it does not contain any date, an erroneous statement that a notice of assignment has already been given would not be defective if it brings to the notice of debtor with reasonable certainty the fact that the deed does not assign the debt. Okay. Then in that case it is what it is saying, that if it bring to the notice of the debtor with reasonable certainty the fact that the deed does assign the debt, that meaning thereby this notice will be valid. Purpose of notice is communication. Okay. So, within communication if certain things are missing, okay, that will be not so much material that it will cause frustration of that notice, because in the first case where the address was not mentioned, then where the debtor will go and pay that amount and how he will ascertain that. Okay. So, in that case it was said as invalid, and this is the very old case. Now, in the case of electronic era and all, that if there is an email ID, phone number and all which can be ascertained, I think that will suffice the purpose for that. Okay. So, even through the mail notice can be given, but that is the case of 1907. So, that would have been the decision. In this case, that if the assignee debtor can assign, can identify that who is the new creditor for him, who is the assignee, in that case a small or clerical error or something, it is not a material in nature. So, notice will be valid one. There is no time limit for the notice, but reasonable time limit has been said that 1 year. Okay. Then section 132, liability of transferee of actionable claim or liability of assignee of the actionable claim. So, more or less I have already discussed, but let us see that the principle behind this section, that is 132, is that the transferee gets no better title than the transferor. Thus, the transferee takes all the equities and also the liabilities of the transferor to which the latter was subject at the time of assignment. Okay. So, there are two illustrations has been given under the bare text itself. So, first it says that a transferor A transfers to C a debt due to him by B. A transfer to C a debt which was due to him by B. So, A being then indebted to B, C sues B for debt due to B to A, okay, because it has been transferred, then now C can sue to B. In such suit, B is entitled to set off the debt due to A to him, although C was unaware of it at the date of such transfer. Okay. So, notice is not much important, but it has been said that although the C was unaware that something was happened, then it will be even though it this will be liable and B can set off the debt. A executed a bond in favor of B under circumstances entitling the former to have it delivered up and cancelled. B assigned the bonds to C for value and without notice of such circumstances. C cannot enforce the bond against A. Okay. A executed a bond in favor of B under circumstances entitling the former, that is A, to have it delivered up and cancelled. Okay. B assigns the bond to C. Okay. So, in that way, this when the C is going to enforce it against A, then it can't happen. Okay. So, principle of this section is that no better title can be transferred to assigner, because here C had no title in that way. So, C cannot do that. Last is warranty of solvency. A warranty of solvency is not implied. Warranty is sometimes given by the transferor as a precautionary measure that the debtor is solvent, so that the transferee becomes assured that he may not lose his claim. The warranty of solvency of the debtor is limited only for the time of the transfer. Okay. It is limited to the solvency at the time of the assignment. Where the transfer is for consideration, such warranty extends only to the amount of consideration. This section is applicable only where the transfer actually gives such warranty. The parties may have any contrary agreement between them. Okay. So, this is a kind of things, that means transferor is saying that, see Mr. C, I am going to transfer my own claim to you, you are going to take it, but I am assuring you that the person whose claim it is against the person against whom my claim is, that is the solvent person. Your money or your claim is not going to be frustrated. And what will be the amount? Amount will be, first of all, that at the date of the transfer, up for that amount it is solvent. Second thing is, if there is a consideration transfer by consideration, in that case amount up of the consideration up to that amount, solvency will be taken into account. Okay. So, it is a transfer of actionable claim can be made by way of sale as well as by mortgage. Section 134 applies, provides that where a debt is transferred for the purpose of securing an existing or future debt, the transfer debt, if received by the transferor or recovered by the transferee, is applicable in the following manner. Firstly, that it is applied in the payment of cost of such recovery. Second, towards satisfaction of the amount for the time being secured by the transfer. Third, if any residue is left, it is belong to the transferor or other person entitled to receive the same. So, it is all about the transfer of actionable claim. Okay. So, this is the 19th module. So, in the next module, now I will cover exchange. Okay. So, thank you so much, thank you all.